Okay, welcome everyone to our afternoon panel on current developments in transnational regulatory standards. I'll be your moderator, Steph Tai, faculty member at UW Law School. We will hear in this order from first Fred Einbinder from the American University of Paris, talking about a comparative law perspective on international resonance in transnational anti-corruption law. Then we'll hear from Vera Corsen from the University of Akron, hearing the non-disputing party, the role of comparative law in interpreting international investment treaties. Then we'll hear from Henry Ordauer at St. Louis University, talking about the Uniform International Tax Collection and Distribution for Global Development, utopian BEPS alternative. Then we'll finally hear from Jared Wong from the University of Pacific, talking about reconceptualizing the legislative stabilization clause. What we'll have is around 15 to 20 minutes for each speaker. And if you go well over, I'll start doing hand waving and stuff to stop you so that we have time for discussion and questions afterwards. Please hold off if you are a member of the audience or even some other panelists from asking questions until afterwards, just to sort of make things a little more manageable. Feel free, by the way, to ask questions via chat or by raising your hand. Happy with either. I'll just be monitoring the chat periodically to see what comes up. All right, take it away, Fred.
Well, thank you, and good afternoon to you all. It's good evening here in Paris. Yeah. And I don't know if I'm going to take my 15, 20 minutes, and I don't want to break any rules, but it's going to be awful late when all the panel's over. So maybe if there's a question or two at the end, you'll let me take it, because I don't know if I'm going to make it all the way, but I'll try. Just to begin with a bit of a disclosure, and that explains, I believe, why I'm so interested in enforcement mechanisms rather than the standards of the law. Is I've spent almost all my career in Paris working for large French multinational companies, and I was general counsel of Alstom. I don't know if anybody knows anything about corruption, but Alstom received in 2014, at that time, the largest fine for corruption from the Department of Justice in history of $772 million. I was no longer general counsel. I'd left in connection with this a few years back, but that may explain why I tend to emphasize enforcement, having lived not the record-breaking fine, but certainly the beginning of the enforcement mechanisms. And corruption has been something that I've always been interested, not just academically, but in practice. And I'm from the South Side of Chicago. Maybe that has something to do with it. I think it might, by the way. I'm not completely joking about that. So just the title, resonance. Why do I use that term and not international norms? Well, I think it's because just the term international norms bothers me in general, and particularly in this area, and I think you'll see why as I go through. Resonance comes from writings of Rachel Brewster, who I haven't met, but has written just brilliantly in this field, particularly of transnational, and I emphasize transnational corruption law and transnational corruption law enforcement. That's really the key. I think we can state today, and then I'm going to come back into history to make sure everybody follows, that the enforcement mechanisms, and certainly the law of anti-corruption, is truly transnational by now, and it's reached a bit, you could say, a state of maturity. One point in my paper, and I feel very strongly about that, is when I say maturity, I don't mean to suggest that means it can't go backward. And in fact, I think it will. And when I say backward, that doesn't necessarily mean it's bad. I think we generally have this view that progress is always forward. Well, progress might sometimes be backward in that respect, and I'll explain in what I call the boomerang effect, which I would suggest is not peculiar to this process of national, international, comparative law, the interplay of, clearly in this area, US law, which was unquestionably and still is preeminent, being adapted and being adopted by other countries. It's never a very, very smooth process, even though right at this time, we're in a period where it's smoother than it ever has been. If people will just a few minutes interrupt me if everybody knows this, but everybody might not. The transnational anti-corruption law really begins in the US in 1977 with the passage of the Foreign Corrupt Practices Act. And that's interesting because nothing happens really for at least 20 years. And that's interesting in itself. And why is that? The reason I think is that it was not an idea whose time had come. It went through the US Congress post Watergate and post an enormous scandal where it was found that Lockheed, in particular, had bribed the Prime Minister of Japan, the royal family, the Netherlands, various peoples in Italy. And there was a very strong reaction on geopolitical grounds. And it's interesting. I don't think this would have happened had it not come precisely at this time when post-Watergate, there was a concern about morality and also the position geopolitically in the US. And I think that's interesting. So nothing much, if anything, happened outside of US borders. And note the term, it's the Foreign Corrupt Practices Act. It's extraterritorial. So we're into international law areas. It's designed to deal with something that had never been dealt before, and that's bribery outside of one's country's borders. Bribery within, even though practiced by many, many countries, has always been, since the beginning of time, illegal and not well thought of. But the concept that one could go after, let's say, a US company, well, for 20 years, only a US company, for bribery outside was novel and wasn't very much embraced even in the US, let alone anywhere else. So for 20 years, it kind of vegetated. And this may happen in other areas that others are far more familiar than I, but environmental law, climate change. Nonetheless, it's interesting, the 20-year, some things do happen very gradual. People, scholars, practitioners begin to become aware that this exists. And certainly the very large American multinationals took note of it. They weren't too worried about it. There was essentially no enforcement, but except for Lockheed and a few others, but it was there. So people started to slowly become aware, and there was a movement from the US, from US companies, to make what is national law that is extraterritorial by definition. And that's important because the French in particular is, well, it's extraterritorial, it's bad. It's by definition extraterritorial to make it something that could become an international norm, if you will, that it would resonate. And companies in the US and the US political structure started to push the OECD. And that's the key organization. The UN's very involved in that. Sorry, that's my own prejudice because I'm here where the OECD is, but working for multinational, that's the international organization that really has made the most of this whole area, not the UN, not others. It's really the OECD in practical terms. So 1990, end of 1997, 1998, 20 years, fairly miraculously, a couple of countries called the US bluff, and somehow this convention comes in, which nobody was that very excited about. And there it is. And that changes things dramatically. For the next 10 years, there's still very little enforcement, particularly outside the US, basically none. But the norms are developing. And one thing that's very important, could be a model in other areas, and I'm sure some of you have seen this, is it's hard law. There's an international treaty. All of the OECD countries and a few others who became signatories, Argentina and a few other countries, about 35 at first, and now it's 44, accept this. And there is the development of an international law. And in the next 10 years, 97 till 2007 or 2008, you see truly the development of an international norm, even though I'm hesitant to use that term, with respect to the law. And what about within the OECD? Well, they have this peer review mechanism, a soft law, consensus, so who really cares? It's interesting how effective the OECD peer review for foreign corruption working group was and still is. Countries look at it. You go through, it's private. They don't name a company that's causing problems, but they give a report. There's a report card, if you will. It's very well done. And this very soft, consensus-oriented pressure has helped to resonate and develop a way of working transnationally. So what happens in 2007, 8? This is important in my paper. I chose 3 major cases, crises, if you will. There's been others, but these are the 3 most important. Siemens. Siemens isn't just any company. Siemens is Germany. It was the biggest company in Germany, a national champion. Problems here are always with national champions. The company I worked with was a national, still is a national champion. And that's where you have a crisis, because you have another law or an international norm and domestic law impinging on fundamental economic, political, and legal questions that are very, very different than the US, particularly in a civil law system such as Germany. But oddly, in my view, Siemens works. They changed the management. This did not happen at Alstom. The most powerful man in Germany at the time was the president of CO, happened to be an in-house lawyer originally, but he wasn't the most powerful person. The most powerful person was Merkel. And Merkel clearly did not protect him, so he goes, and they end up paying over $1.5 billion equivalent of dollars to Germany and to the US. And that's interesting because it represents a landmark. It sets a blueprint for the interplay of national, international adaptation. It's always the US pushing, but in Siemens, it's also the Germans. And when people study this, they tend to forget that it's the German court system, German prosecutors that started all this. And for some reason, they were allowed to proceed. They were not allowed to proceed in France or in England, for that matter, when similar things happened with my former company and British BAE, British Aerospace, when they were caught in a major Saudi problem. And Tony Blair said, no, we're not going on this, despite the law. And the House of Lords followed Tony Blair. So the German experience was very, very interesting. It sets a blueprint. And that blueprint says, in my view, you need your home country. You can't have the imposition of a national law on another unless the home country, in this case, Germany, is involved. And that's what happened. There were some setbacks, as I mentioned, in France and the US, but slowly, and I think this is the way enforcement operates transnationally, gradual familiarity, and then something enormous, a shock. And Siemens was a shock, but they come out of it very well, and you have a success. And that success, Siemens, that's why my companies, why other companies started to look at things, resonates. It's not just the law, it's the fact that this major company was successful in cleaning itself, even though it cost a lot of money. And it was a major difference because we have American legal principles. And we know we're comparativists. Germany and France and Italy and other countries, even the UK, do not have, or certainly did not have, the enforcement mechanisms of the US. And the most important one was plea bargaining and deferred prosecution agreements, which really became important in the US only in 2003-4 after Enron and Arthur Anderson. And it became very, very important as the major tool for this process of transnational resonance in the corruption field. So one point is everyone thinks, and I don't, that you need this mechanism. What counts as the mechanism? I think the mechanism is important, but not fundamental. What's more important is a political will, a company will, as Siemens had and other companies did. At the time, German law, even today, does not have formal plea bargaining. And in almost all countries in continental Europe, Italy being an exception because, frankly, the mafia had to do something, plea bargaining didn't only not exist, it was illegal. And a prosecutor who even suggested indirectly, this was Swiss law and Swiss practice, that maybe we'll have a deal, risk going to prison themselves. So there was, and still is to a certain extent, a very strong legal principle based on the legality principle of civil law against American ways of doing things. And slowly this has changed, but in order to effect change, I believe, and this may have parallels in some of the other areas that people will be talking about, or environmental law and international criminal law, you need for home countries that have different systems to graft the legal transplant and adapt it. And if they don't do that, what inevitably happens is you get rejection, but that rejection, we found, is not immediate. So particularly legal elites, international law firms, oh yeah, we now have the American thing, everything's fine. It isn't. There's a boomerang that's waiting. And I think that is probably something that happens in other fields besides corruption. So it spreads. Odebrecht is the second, in my belief, in my view, enormous case, end of 2016. And there we see things not limited to Europe. Odebrecht was the largest construction company in Brazil, one of the biggest and most reputable companies in Brazil, and it was bribing everybody everywhere. So it was a big scandal. You would think they'd be protected, particularly in Brazil, for reasons that are sometimes hard to fathom, both Siemens and Odebrecht. They're not. The scandal brings everybody in, a major political upheaval in Brazil. And here's what's fascinating. It spreads throughout the entire continent and also into Africa. We have, even today, Odebrecht corruption cases everywhere. Peru, Chile, Argentina, Angola, Mozambique. So that's a landmark because we see from the European base emanating from the US, resonance now worldwide throughout the South African continent, and many countries in South Africa now, not many, a few have joined the OECD, others wish to, and others, such as Argentina, who are not ripe to join, have always been signatories and they'd ratified the OECD Anti-Bribery Convention. So that's fascinating. Just jump because time goes by. Third landmark case, and that's the way to approach this. That's the way I tried to do in the paper, in addition to talking about innovations and local legislations in France and in the UK. Those are the most famous, which came about because of not coercion, but they messed up. And then they realized and they adapted American concepts, but in a French way and in a UK way. And I think that's very interesting. Last, and certainly not the least, is very recent, just a year and a half ago, Airbus, which is now the largest aviation company in the world. It's a French-based but European company. They, of course, have been involved heavily in bribery. They came clean. And there we see the maturity, because the American authorities, the UK authorities, and the French authorities cooperated very smoothly in ways that one would never have imagined could possibly happen 10 years earlier. And that's because of comparative law. I mean, it's not because they became members of our society, but they practiced comparative law by going to each other countries. And there was a parliamentary not debate, but inquiry. They went to see the Department of Justice. There was a lot of work done, and I believe that's essential for this process to happen in any field of law. And it did happen. And then they came up with this very heavy fine, like in the two previous cases. But the biggest part of the fine went to France, where in years past, it would always go the lion's share to the US. Now the US is stepping back. It gets 10% because it coordinated, it helped. The French and the UK, but mostly the French, got the lion's share. It goes to their treasury. And that's very important because it takes away the argument that the Americans are just going after everyone in the world, to have a level playing field. And you can imagine in other countries that are in competition, no one believes that. They believe that the Americans are just defending their own countries. And it's hard to come back with an argument against that when all the money for bribery, not in the US, not in France, not in the UK, but somewhere, goes to the US Treasury. So the Americans have truly learned. And I think it could go back, but that's a very important step towards maturity. First, Siemens, home country, civil law, common law. There's not a compromise, but there's the beginning of understanding, even though they're acting fairly autonomously. Second, worldwide spread to Asia as well, even though it hasn't been an enormous case there with an Asian country as in Brazil. And then you have Brazil. And then finally, we have the mature situation. Yes, you're stopping me?
If you can wrap up, that would be great.
Yeah, so I just noted three cases, but what did they teach us? They teach us that it's possible, and there's two resonance institutions that I mentioned. One that has been highly successful, and that's the transplanting of plea bargaining, deferred prosecution agreements for corporations. The second, which has not been as successful, and I'm not so sure it needs to be, is whistleblowing. For a lot of cultural more than legal reasons, there's been a lot of resistance to American style. America has money. That's the way it's viewed here, and there's some validity of that. So there's resistance. In the paper, I also mentioned putting to reverse residence. And this might be useful in other fields as well, where it's not just the US resonating its law abroad, but other legal systems resonating back. And I think there's two areas. One is the French and others have private right remedies. So it's not just the authorities, it's NGOs, civil society, who can bring cases and obtain money. And that's been successful, going after some African kleptocrats. And given France's historic interest in Africa, it's amazing this has happened. Maybe that's something that the Americans can adopt. A lot of scholars have pushed for that. It hasn't worked. And the second is, we all know that plea bargaining is very much criticized in the US, even though we use it for almost everything. And one of the big criticism is arbitrariness, prosecutorial abuse. In other countries, and here the motto would be England, and this worked on the Airbus case, the judge plays a very important role in approving the settlement. It's not in the US, it's a rubber stamp, always accepted. They don't even look at it. In England, the judge, she was just brilliant in analyzing. She approved it, but she set rules for the future. And she just didn't say, okay, you guys agreed, the company and the prosecutor, I have nothing to do with it. And I think that type of resonance coming from the continental and UK tradition that, you know, the public has its say. It's not just two private parties, the government and private party. We need an independent approval, of course, granting significant discretion to the authority and to the prosecutor and to the company. But the judge looks it over, and the English, I think, are just marvelous at doing that. Okay, that's it. Actually, it took longer than I thought. So thank you very much for listening.
No problem. That was really fascinating to see the way that different norms pass into other areas. And you were mentioning environmental, that's more my area. So I can see some similarities there. Next, we have Vera Corsen talking about, well, I've already read everyone's paper's name, so just take it away.
Okay, thank you all. So I'd like to share my slides and let's see if it works. Okay. Okay.
Yep.
You guys note that you can see them? Wonderful. So I think I should be able to move along then. Thank you again for a wonderful panel, and I very much look forward to hearing all other presentations here. In turn, I would like to attract your attention here to the issue of, broadly defined, the issue of rebalancing international investment law and arbitration. And so I will be talking about current reforms that are being discussed, and some of those are ongoing. And as part of these reforms, we'll be focusing on so-called non-disputing party submissions in investment arbitration, and specifically whether we can engage comparative law to highlight the view of these parties in investment arbitration. So this is a roadmap of my talk today, but please let me know if I'm exceeding my time. So let me start with the motivations for these projects. Several reforms, as I've mentioned, are currently ongoing with the view of what people call reforming international investment law and arbitration. And for those of you who are less familiar with the topic, I perhaps will outline just a few. There is extensive work happening as we speak at the ancestral level, UNCTAD, ICSID. In those organizations are reviewing the investment arbitrations provisions in case of ICSID. UNCTAD is helping states to revise and amend their investment treaties. Ancestral has a broad agenda of issues in the area of investment law and dispute resolution, where they're considering how to help the participants of the process to improve the whole experience. Energy Charter Treaty is being revised, and then there are, of course, numerous revisions of the investment treaties on bilateral level. Well, there are many goals of these projects depending upon, to whom you speak, essentially. But I think there is this overbroad goal that we often hear, that is to rebalance international investment law and dispute settlement. So rebalancing becomes a broader topic here. And as part of such rebalancing, what we are trying to achieve is, generally speaking, to provide more rights to host states in the investor-state dispute system, so that they have bigger say as to how a foreign investor, for instance, operate in their jurisdiction, that the host state's right to regulate for the benefit of the public at large is not weakened by the investor protection treaties that the host state concludes, etc., etc. So if you go back to the origins of the international investment treaties, generally speaking, they have been originally drafted as treaties for the protection of foreign investors. With the current reforms, what we are trying to achieve, we are trying to rebalance this system by providing more visibility to the rights of the host states that will be accepting these investments. So I listed here a few broader topics of revisions that you see. This would include the enhancements of the right to regulate. This would be inclusion of various provisions with regard to the right of the state, for instance, to invoke exceptions, to invoke the denial of benefits clauses, and then, of course, to bring counterclaims when it comes to disputes as part of investor-state dispute settlement. So I would define these incentives here and general, revisions that we observe as revisions that are targeting the enhancements of the host state's rights. On the other hand, here we are observing various rules in the proposed provisions that are targeting what I would call the regulatory standards. In particular, we are now more concerned as to imposing obligations on foreign investors with regard to operations in the foreign jurisdictions, and even soft law set of rules developed by the United Nations and the OECD with regard to environmental protection, sustainable development, human rights, and what really fascinates me, soft law provisions on corporate social responsibility have been incorporated in some of these treaties, and one may argue are now enforceable by arbitral tribunals. So the role of comparative law in these initiatives is really substantial. I mean, when it comes to treaty drafting and revision of arbitration rules, institutions consistently talk to each other. Regional organizations borrow from one another. In instances where we are revising bilateral investment treaties, again, countries borrow from one another or model their investment treaties based on model treaties that have been developed in this field. If we turn now our attention to the investor-state dispute settlement, where arbitral tribunals are engaged in treaty interpretation and then applying provisions of investment treaties with regard to disputes to resolve a particular dispute at hand, again, they're consistently borrowing from one another. And I will show you a little bit of statistical data there. There is an increase in communication between legal scholars in this field and, of course, prior arbitral tribunals through borrowing from prior arbitral decisions. And so all of this made me wonder, can we engage comparative law then to highlight what the so-called non-disputing state parties in investment arbitrations think? To explain it, in other words, in a standard investor-state arbitration, you would have a private entity bringing a claim in arbitration against a host state for alleged violations of investor protections that were granted in a bilateral treaty. There are, of course, regional treaties, there are free trade agreements with investor protection chapters, but a standard agreement in this field would look like a state-to-state agreement between two governments providing benefits to the third parties, foreign investors. And so the enforcement of these agreements rests with the private entities who is suing the respondent state. And in these settings, you generally don't get to hear what the non-disputing state party thinks, the home state of the foreign investor. And with this question in mind, I decided to explore a few elements of these reforms and analyzed how we can highlight the state position here. And let me show you what the ISDS reform looks like from the position of the UNCITRAL and UNCTAD. If you're only focusing on treaty interpretation, perhaps this is just an insight. It's not meant to be a comprehensive review of the reforms. But the UNCITRAL, for instance, is seeking to ensure consistency in interpretation of treaty provisions as part of dispute settlement. So UNCTAD, on the other hand, to the extent that they're helping governments now to revise investment agreements, they're also underlining the importance of treaty revisions, ultimately to ensure that there is certain certainty and enhanced predictability of outcomes in this decision for everyone involved in the process, be it a foreign investor, state party, or arbitral tribunals. So now, those are the goals that UNCITRAL and UNCTAD have underlined with regard to state participations. But now let's go and see, with reference to the OECD study, it's a little bit outdated, but they provide us an insight as to In cases where arbitral tribunals already have to engage in treaty interpretations, and they are looking at other sources of authority in making interpretative decisions, what are the sources of interpretation we consistently see arbitral tribunals to rely on? And I'm particularly concerned to what extent among these sources you will hear citations relating back to the state view on what the investment agreement meant to do. And so if you look at this data from the OECD, surprisingly perhaps, you would realize that instead of going to the original treaty provisions or subsequent agreements between state parties as to treaty interpretation, tribunals are more engaged in talking to one another. So decisions of other arbitral tribunals in terms of citations to those are more frequently referenced by subsequent tribunals as opposed to, for instance, sources that come from state parties. And this can be like travaux préparatoires, object and purpose of the treaty that is being discussed in the pending arbitrations, subsequent agreements between parties to a treaty. So I would argue here that, in fact, state parties and what I am mostly interested, non-disputing state parties, don't get to say too often what they really think about a treaty, because tribunals, as it stands right now, are more relying on prior tribunal decisions than submissions by state parties engaged in a dispute. And so various ideas have been put together as to how do we make state parties heard in this process, right? And one of the view of ensuring consistency and making them more visible, and I'm not talking now about respondent state, I'm talking about the other state, non-disputing state parties. Well, jointly, for one, they could put various joint interpretations, declarations within the meaning of the Vienna Convention on the Law of Treaties, following entry into force of investment agreements between them. And at least these joint statements can help along the way when an actual dispute arises. They can help the arbitral tribunal to interpret a treaty provision and then apply it to a dispute at hand. Alternatively, and this is what some recent agreements have been doing, alternatively, state parties could develop a mechanism to jointly determine the law or provide interpretations so that when there is an actual exercise that arbitral tribunals are engaged in and they need to interpret a treaty provisions, tribunals then can rely on such mechanism for consistent treaty interpretation that would provide the view of both states involved. And finally, this is my asterisk here. And the goal of my project will be ultimately to explore this extensively. We could provide for non-disputing state parties a route for presenting their views as part of dispute resolution, and it could be, non-disputing state party submissions or amicus curiae submissions in pending arbitrations. And I think this would be the essence, the best view from the other state that you could achieve for a variety of reasons. And so UNCTAD echoes this approach, and they indeed say that enhancing the state's role in dispute resolution is paramount here. And they also underline that non-disputing party submissions and increasing their visibility in investor-state dispute settlement would be very important as we move forward with the current reforms. And so I won't be listing here, but in line with this goal of enhancing state views and making them more visible as part of dispute settlement, we already see some initiatives at the state level where countries are revising their bilateral investment treaties or introduce this mechanism for treaty interpretations that I was referring before. But I don't think we see enough submissions, and we don't see enough changes in treaties and arbitration rules that would permit non-state disputing parties to be heard in actual disputes as they develop. And so this is still an early project, but the goal for me is to explore the role of non-disputing party submissions in ISDS, and in the context of this interpretative practice that arbitral tribunals are engaging, to explore the role of comparative method as a means of achieving greater consistency here in treaty interpretation. And I want to achieve this consistency not only across different provisions of treaties, but also across different arbitral decisions. Specifically, I want to engage arbitral tribunals as part of treaty interpretation, not only in reading and assessing current submissions, but also finding a way, with the help of arbitration and comparative law, to hear prior submissions and make them relevant as part of treaty interpretation. And so this is, as I've said, an early project. I'm looking into actual cases where arbitral tribunals considered non-state party submissions. There were several of those, but mostly submissions that we see, for instance, from ICSID, not all of them were granted. Mostly they have to do not with the non-state parties, but third parties, NGOs. And so you don't get many cases where you would get to hear the non-state party in this type of arbitrations. But there are some preliminary observations that I can make already. I argue in my paper that non-disputing state parties, the other state in these bilateral treaties, are uniquely positioned in cases of pending arbitrations to shed light on the history, purpose, and meaning of the investment treaty. And what is more important, if you pause for a second, to the extent that they are non-interested parties in these disputes, unless they, of course, want to interpret their own treaties for the benefit of actual investor who is suing the respondent state in the moment, I still think that they are more uniquely and objectively positioned to present the view on the treaty meaning as opposed to the respondent state, who will be making a defense in the case and perhaps trying to shed the light on the treaty provision in view of the outcome that they would like to achieve. And unfortunately, current rules don't permit these submissions to be accepted in every single case. To the extent that submissions by non-disputing state parties are permitted by some investment treaties and also arbitration rules, generally they are permitted on ad hoc basis if the disputing state parties agree. And I think this shall be changed. And I think what the normative argument of my paper will ultimately look like is the statement that essentially, if we really are after consistency and predictability in treaty interpretation and dispute settlement, we need to find a way to make arbitral tribunals hear what the non-disputing state parties think through submissions in pending arbitrations. And this is where the comparative law might play a role. We perhaps should engage in comparative analysis by also requiring the parties here to submit to the arbitral tribunal prior submissions relevant to a particular treaty interpretation. And furthermore, submissions and arbitral awards that relate to the same treaty being interpreted in this arbitration at the moment, and of course involving state parties. Now having sufficient submissions that covers the views of both countries in this dispute over a period of time where they both were presented as a respondent and non-disputing state parties, I guess tribunals will be sufficiently equipped to make their determination to interpret the treaty and ultimately apply it. And so those are my preliminary solutions in this project, and I welcome any comments in this regard. I mean, a straightforward solution to increase visibility of non-disputing state parties would be to revise and amend investment treaties and arbitration rules to permit these states to make submissions in pending arbitrations. And we can look for more direct ways of these submissions to be made as opposed to rely on the current system where we are engaging ad hoc process and generally only permit those submissions with regard to which disputing parties in arbitration agree. And so if a respondent state, for instance, does not want a submission by the other state to go forward under the current system, most of these submissions would not be permitted to go into arbitrations. Of course, even if they're permitted to make submissions, non-disputing state parties might not have sufficient incentives to do so. So the reforms that are being discussed right now with regard to rebalancing international investment law and arbitration should look for ways to provide incentives for these states to speak when an actual arbitration arises, to outline their view on the treaty being interpreted. And then this is the bullet point number 3, comparative law insight. I don't think we should limit our contributions here from a non-disputing state parties to a single submission relevant to an actual arbitration. I think we should find a mechanism to provide other submissions to get a more objective view on the treaty interpretation here. And specifically, I believe disputing parties should be required, instead of picking and choosing, they should be required to provide to an arbitral tribunal prior submissions that relevant states have made and arbitral awards that involve the same treaties and same parties in the past. And finally, providing for a mechanism that would allow arbitral tribunals, in view of all of the submissions made, to make a comparative analysis and borrow and interpret treaty provisions as needed, would be essential here. And only with such a mechanism, I guess, the greater consistency and predictability of arbitral awards and treaty interpretations can be achieved in this regard. Okay. Thank you. Steph, I think you're
Thank you. That was very fascinating. I was on mute, sorry. All right, up next we have Henry Ordauer talking about uniform international tax collection. And
I'm going to share my screen here as soon as I figure out how to do it.
It's sharing.
Okay, it's sharing. There we go. Okay, so I'm going to talk about tax a little bit. And before you decide to leave the room, just give me a minute or two just to get started, and then you can leave after that. 136. I assume that some of you reading the newspaper in the last couple of weeks know the significance of this number. 136 countries agreed to the two-pillar OECD approach, Organization of Economic Cooperation and Development approach to taxation, a combination of projects to stop base erosion and profit shifting, which I'm not going to talk about particularly. But the second part of it is a global minimum tax. This is amazing. 136 countries agreeing to this. We can't even get 50 states who are all under the same basic system to agree on how to share income, the right to tax income within the United States. This came particularly to a head during the pandemic when a number of states at cross-border locations continued to tax commuters who were working from home while their home states were taxing them as well. New York, New Jersey, for example, Illinois, Missouri, Missouri, Kansas, and so forth. So we haven't resolved that issue even among the states. Okay, but what does a minimum tax do? Along with the rest of the BEPS project, it captures revenue for affluent economies unless the non-affluent economies impose the minimum rate of tax. And we're talking about income here. We're not talking about any other tax except income. So, okay, this sounds like a really good idea. It encourages non-affluent countries to collect taxes. But at the same time, it destroys their opportunity to use the income tax as a way to capture capital investment. More important, some of these countries don't have the infrastructure that's necessary to compute and collect the taxes, so they're going to have to piggyback onto the major economies' systems, or they're just going to have to relinquish the revenue. That's certainly a second possibility. And furthermore, they may well decide to find other ways to compete for taxes. For example, by defining the tax base in a different way, because there isn't a uniform tax base internationally. There isn't even a uniform tax base between the United States and Germany. We don't compute the base for the income tax the same way Germany does, or France, or Belgium or in the Netherlands or the UK. There's going to be still going to be competition there. Now, there are certainly things that we can agree on. Multinational enterprises artificially shift profits to minimize taxes. Okay, no argument about that. Tax planning drives too many business decisions, and there's an awful lot of talent wasted on trying to diminish tax liability. Multinational enterprises should pay more tax. Okay, well, we can all agree to that, especially those of us who are, all of us here who are academics. We don't get paid that much, and we see that, that we think that other people should pay more tax. And we agree that multinational enterprises and certain other taxpayers are not paying their fair shares. But at the same time, while we're doing these projects like the global minimum tax, countries are not budgeting for the increased revenue from closing the tax gap. Neither BEPS nor the global minimum tax talk about are incorporated into the budgets ahead of time, because there wasn't a project that was going to be successful yet. And we do know that there are vast resource disparities that exist internationally. So we can all agree on these things. Things that we don't agree on is what a fair share is. We don't agree on what a fair share is. We've decided that 15% is the good minimum tax rate. But beyond that, we don't have an idea of who should pay how much, at least not a total agreement on it everywhere. And more important, there is going to be additional revenue raised from closing the tax gap, from BEPS, from this global minimum tax. And how should we distribute this revenue? The affluent jurisdictions are going to grab most of it. And if they're really benevolent, they'll share a little bit more of it. Right now, the United States budget includes less than 1% of the budget for international development. So maybe the United States will push that up closer to 1%. Maybe some other countries will do a little better than that. But even within the minimum tax, we don't even know how to allocate the taxing power. Should it be on basis of residence, a consumption, market share, value creation, the benefits, costs and expenses? We've had all kinds of different ways of doing that and thinking about how to do that. And yet we don't have a consensus on any of those things. Some of you may recognize this quote from Bertolt Brecht, the Threepenny Opera. First comes nourishment, but using the animal word for eating. Then we get to the morals. So this takes me to the question of poverty. There is relative poverty in some places in the United States, in the UK, in the EU. But the interesting thing about those areas is that we have adequate resources. There's no reason anybody in the United States should be starving. We have enough food resources. We have educational opportunities. We have shelter and clothing for everyone. The problem comes from not distributing these things in a reasonable manner so that everybody has at least a minimum standard. And in my paper, which is one of 3 papers in my utopian view of taxes, this is the third of the 3. I have 2 others in Florida Tax Review that are, one's on a grand unified global tax, income tax, another one on capital as an elusive tax object. But leaving that aside, in this paper, I have a part of it that deals with revenue distribution in St. Louis County, Missouri, where I live, and in terms of supporting the schools. And it's very uneven, unequal among jurisdictions in the county because it's based upon where you live. And, if you live where housing is more valuable, there's more money for the schools and so forth. But this is a distribution of existing resources, not a problem. It's just a question of getting the distribution better. But there is absolute poverty in the world. there are countries that don't have sufficient resources. There's starvation, there's lack of housing, there's lack of clothing, there's lack of education. Should we be thinking about doing that? So then we get to the moral claims, okay? For the affluent countries, we have some moral claims for why they get to keep the additional revenue that they've just grabbed. The poor deserve to be poor and the rich rich. That's a pretty simple one. Property trumps people. What's mine is mine. Industriousness and creativity in the affluent world versus laziness in the non-affluent world. And just general moral superiority. And what it really boils down to is the luck of the draw. I am grateful every day of my life for the fact that my grandparents thought of leaving what was then the Austro-Hungarian Empire and coming to the United States, where I got to grow up in a land of plenty. Well, you know, I was lucky. This is luck of the draw, isn't it? So the BEPS projects, base erosion and profit shifting projects of the OECD capture additional revenue for affluent economies by shifting income to those affluent jurisdictions. And even when they start talking about a fair apportionment of the tax base, however you do that, you're still not going to solve the problem. We don't have uniform rules. We see a lot of convergence in tax rules. And that's, you know, comparativists say, well, you know, that's to be expected. But there's not enough. We need a level playing field. We need greater convergence in tax rules, but base differences in here. The base has to be uniform and the rates have to be uniform. And then what should we do? We should collect the tax centrally, internationally. Look, we got 136 countries to agree to a global minimum tax. Maybe we can get them to agree to an international tax collection agency. We get them to do other things. The European Union, after World War II, ceded hegemony to Germany, economic hegemony, by joining the European Union, the European Economic Community, and Germany was dominant. So maybe it's not so far-fetched. Then what we got to do is distribute the money that we collect internationally from taxes based upon contextualized need. Not just small budget allocations by affluent countries like we have today. The affluent world retains its basic revenue. We're doing just fine. I mean, look at the pandemic. In the pandemic, the EU, the UK, the US, all did just fine. They managed to keep their people fed. They managed to keep people living in their housing without any additional revenue. Let's take all of the incremental revenue from this 15% global minimum tax. Let's commit to devoting that and any additional revenue we collect by having an international agency to the relief of poverty. And that's where we ought to be going with the tax revenues, not grabbing more for the affluent countries. I noticed that Spain already issued a new budget which took account of the 15% global minimum tax. We need to address this before we lose the opportunity. So what I'm proposing, and I've proposed before, is an international taxing agency working with uniform rules and collection, distribution based upon contextualized need, and where we have issues like corruption, we might consider doing direct distribution. In fact, there's a project right now that the UN is sponsoring to distribute funds directly to Afghan citizens and keep it away from the Taliban. I just heard about that, saw it in the paper this morning. possible direct uniform distribution of revenue based upon a uniform basic income to circumvent the local collection, a uniform basic income for everyone. Now, it's not uniform in the sense that if you live in an affluent country, you might get more, but based upon this contextualized need concept. All done.
All right, thank you so much. Last but not least, we have Jared Wong, who I think is also going to share some slides.
Indeed, I am, if I can figure this out. So give me a second here.
Okay.
Let's see.
All right.
Okay. Okay, well, I want to thank the organizers for putting together the conference, and also to thank Steph for moderating this panel. So I'm talking about the legislative stabilization clause. Now, stabilization clauses do something quite special. They stop time. More specifically, they're provisions that freeze the laws, rules, and regulations governing foreign investment as they existed at the time that the particular investment was established. What this means is that a host state is liable should they fail to shield an investor from any subsequent laws that they pass that adversely impact that investment. In the contractual form, they're ubiquitous and long-standing. And these are priced by investors for good reason, right? They shield their investments from an increase in tax rates, for example. So the quid pro quo here is pretty clear. The host state gets the investment in return for the investor getting that stability under the stabilization clause. Now, many countries have gone further and have introduced these stability clauses in the legislation, hence legislative stabilization clauses. Now, because of their unilateral nature, because what this legislation do is basically to accord the investor the right to stabilize their investments without, in fact, requiring the investor to agree specifically. The scholarship, or what little scholarship we have on legislative stabilization clauses, have focused on whether these LSCs are in fact enforceable. But I think that there is an ancillary and additional question that we need to ask, which namely, whether they in fact attract foreign investment in the first place. The unspoken assumption is that these legislative stabilization clauses function much like the contractual ones in similarly attracting foreign investments. But if you look at the data more closely, it's not clear that that's in fact is what is happening. Why do we care? Well, we care because, as with contractual stabilization clauses, states are potentially on the hook for their legislative stabilization clauses, in that if they are and they prove to be enforceable and they fail to shield the investor from subsequent changes in the legislation that adversely impact that investment, they will be on the hook. And so if the legislative stabilization clauses are not in fact attracting investors, in other words, the investors are investing anyway, and they're not paying attention to those legislative stabilization clauses in making that decision, then these LSCs are, a particularly poor bargain for host states, right? Because they're on the hook without getting anything out of those stabilization clauses. So to get the full measure of LSCs, we really need to consider both the question of their enforceability and whether they in fact increase FDI. And so to redress this scholarship imbalance, my co-author and I combed various case studies, passing really for any data that links LSCs and FDI. And it was hard to do this because a lot of the data just looked, to the extent that they considered stabilization clauses, looked at stabilization clauses in general and haven't necessarily focused on LSCs. But based on what we could glean from the case studies out there, as well as an analysis of the case law, we are now proposing a new taxonomy of LSCs that divides them into 3 categories according to their structural form and utility. What we're calling the aspirational LSCs, the standard LSCs, and the contractual LSCs. Here's a general description of them, and I'll go into each of them in a little bit more detail. So the aspirational LSC, as its name suggests, is one that authorizes the government to furnish an investor with stability guarantees, but without, in fact, requiring the government to stabilize the particular investment. So an example would be Madagascar's investment law, where it basically states that the government would use its best endeavors, right, to stabilize the investments of foreign investors. Now, it's hard to imagine, right, that aspirational LSCs will attract investors, just because it's pretty clear from the language, right, that the states are not basically on the hook to stabilize any foreign investments. And so if it's pretty clear, it's manifestly clear from the language that they don't attract them, then it's hard to see how these aspirational LSCs can in fact draw in investments. Now, you might argue, well, if in fact aspirational LSCs don't require, right, the government to stabilize obligations, it means there's really no cost, right, to the state doing this. So why not do it? And then maybe you can get lucky and you'll dupe the unsavvy investor into investing anyway. Now, the problem with that approach is that these 3 categories that we're laying out obviously are not entirely discrete, right? It's more of a spectrum, really. And much depends, as I think you can begin to see, on the language of the particular LSC. And so it is possible, depending on how you construct, right, the LSC, what you think of an aspirational LSC is in fact a standard LSC that can obligate the government to stabilize investments and therefore put them on the hook and make them liable in the event that they fail to do so. And so there is a risk, in fact, that they would have to be required to stabilize the investment. And then on the flip side, right, the language, right, just makes it unlikely that an investor will rely on these kinds of LSCs to in fact make a decision to invest in that host state. Now, so what are standard LSCs? In contrast to aspirational LSCs, standard LSCs are what we define as stabilization clauses that promise to stabilize, they just stock stabilization clauses in legislation that promise to stabilize particular national laws or regulations applicable to the foreign investment. And so, for example, Armenia's law on foreign investment does that. I'll let you read it. It basically promises to stabilize any laws that apply to the foreign investment for a specific period of time. Now, in general, LSCs are more recent invention, as I indicated in my introduction, and there are conflicting views as to their enforceability, given their unilateral nature. The relevant case law, because they're newer, is far thinner and much less coherent. Now, the tribunal in at least one case has found standard LLCs to be unenforceable precisely because of their unilateral nature. But more cases, in fact, have found them to be valid and have enforced them. At the end of the day, enforceability, as I was suggesting earlier, really does turn on the language. The upshot and the consensus here is that really standard LLCs are potentially binding on the state. And there are several cases that have determined them to be so binding. Okay, so they are potentially binding. Now we want to ask, well, do standard LSCs attract FDI? Because again, if they don't do that, then, right, this is a bad bargain, right, for host states. Now, we looked at Kazakhstan, which features a standard LSC as a case study for trying to figure out whether they in fact attract FDI. What's interesting about the Kazakhstan case and Zambia, which we also looked at, but I won't have time to go into, is that both of these countries that have standard LSCs, in fact, introduced and then withdrew their standard LSCs. And so one might posit that, look, if in fact LSCs attract FDI, if you withdraw them, right, you would expect the FDI to decrease. And if they do not decrease, then you might argue that in fact, the LSCs do not attract foreign investment. Because we're short on time, I'm just going to say that what happened here was Kazakhstan introduced an LSC, a standard LSC in 1994, and then withdrew it in 2003. They did it in 2003 because FDI was basically on an upward trajectory at that time because of increasing world market prices on petroleum and grain and metal, which are their main exports. And so to protect their economic interests, they started dismantling the LSC, including the 1994 LSC. Now, what happened at that point in time? There was a slight dip, but as we can see, the FDI continued to increase. And so one might argue that this suggests that LSCs, in fact, don't have any impact or standard LSCs don't have any impact on FDI. But it's obviously difficult to draw this kind of conclusion just from FDI, just looking at the FDI, because there's no way to, in fact, isolate the impact of the LSC on FDI. So we can't tell, right, whether in fact the fact that it keeps increasing, notwithstanding the withdrawal of the FDI, is in fact related to the withdrawal of the FDI. Or put in a different way, we don't know, for example, whether had the FDI remained, right, whether there would have been a further increase in FDI levels beyond the ones that we see. At the end of the day, in other words, if we're just looking at the FDI data, the evidence is at best inconclusive, and we cannot really say with any confidence that the standard LSC would increase or decrease, I suppose, LSC. And this is really analogous to kind of the studies that have been done with regard to bilateral investment treaties. There's data going every which way, and it's just not possible to tell to this day, notwithstanding the very extensive studies that have been done by many scholars, whether BITs in fact attract investment for the same reasons that we're having difficulty drawing these conclusions for standard LSCs. What we do know, however, from the case law is that they are in fact binding on the state. So we don't know whether they attract investment. We do know they're enforceable. So these are potentially, right, bad bargains for a host state to simply go with a standard LSC when they cannot say with any confidence that in fact they would attract in foreign investments. This brings us to the third category, the contractual LSCs. Contractual LSCs grant investor stability guarantees through contracts approved by the government, often conditional on meeting particular investment profile criteria. So what's innovative, right, about these contractual LSCs is that while it's the clauses are in the legislation basically promises that the government would give them contractual stabilization clauses if they meet these various criteria. So basically, right, this kind of blends both legislative and contractual LSCs. And they require the government to approve, right, the granting ultimately of these contractual LSCs. An example would be Colombia's Legal Stability Contract Law number 963. Right? Now, the key distinction then between the contractual and the standard LSC is that at the end of the day, in a contractual LSC, a contractual stabilization clause is generated in the investment contracts themselves, which must be authorized by the government. With regard to their enforceability, arbitral tribunals have explicitly, repeatedly confirmed their enforceability. And that's not a surprise, right? Because what they're doing at the end of the day is really affirming the enforceability of the contractual stabilization clauses that result from these contractual LSCs. And this is already well established in case law, right? The contractual stabilization clauses are long-standing, and they would be read, given the agreement on both sides, as generating the obligation on the part of the government to stabilize the investments. So what's then the advantage of the contractual LSC? The contractual LSC, right, because of kind of the mechanism that I've just described, in fact, arguably renders, right, the stabilization clauses even more enforceable than any standard legislative stabilization clause that is held ultimately to be valid, precisely because of the resulting contract. And we also know, right, that investors even in the presence of an LSC will often request or seek a contractual stabilization clauses in their investment contracts as a guarantee, because that's kind of what they're familiar with. And as we know from the case law, from long-standing contractual stabilization clauses, have long been held to be enforceable, right? Additionally, what's advantageous about the contractual LSC is that the mechanism, right, that is required, governmental mechanism that's required for the approval of those stabilization clauses allows the state to monitor and keep track of the stabilization clauses that are generated under this particular contractual LSC. So now we have to ask, okay, we know it's enforceable. Are contractual LSCs capable of attracting FDI? And as it turns out, we have much more compelling evidence that they can attract FDI. And it's precisely because of the mechanism that requires the government in the legislation to approve the particular contractual stabilization clause, right? And we use Colombia as a case study here. And basically what we saw from Colombia's experience, right, is that the 2005 LSC generated an average of 25 contractual stabilization clauses a year between 2006 and 2012, with the vast majority is established right after the clause came into effect between 2008 and 2010. And we also know from a separate OECD report that between 2006 and 10, the government had signed 66 stability contracts worth over 12 billion, nearly 13 billion, right? So kind of these are the numbers here. And so what we have basically, right? And if we look at the FDI inflows, which I've already said is not as reliable a metric, right? We do see a corresponding increase to at the time, right, that the LSCs were introduced, right? But while we are unable to state with confidence that the FDI data is in fact a measure of the LSC's efficacy, we can, right, draw that conclusion much more soundly from the numbers of contractual stabilization clauses generated under the program, right? Because the contractual LSC requires the government to approve the particular contractual stabilization clauses in the resulting investment contract, they can say, look, we know that investors basically signed on to this program, and we know these many, right, signed on, generating this much revenue, and which are attributed directly to the LSC. And we also know, right, what's interesting is we also know, this is not just a case of the investor saying, oh, well, you know, this seems advantageous, I'm gonna just sign up. So regardless of whether I wanted to do this in the first place, this seems to give me an advantage, so why not just sign up? Because if that were the attitude, then it doesn't really tell us that the LSCs, the contractual LSCs, are in fact motivating the investors to make that investment. How we know this is that while the contractual LSCs will promise to stabilize the agreement for a specific period of time, typically they do it at higher rates than the prevailing tax rate, for example, at the time. Now, you might ask, why would any investor agree to a higher rate? Well, because they know that agreeing to this slightly higher rate, right, would mean that they can rely on this stabilized rate for a period of 10, 15, 20 years, whatever the legislation promises, right? As opposed to a slightly lower prevailing rate, which may well fluctuate over the years to, and it's not something that they can rely upon. In other words, because these contractual LSCs often require the investor to agree to a slightly higher rate, albeit for a longer period of time, we know that the investor actually has to think through this process, right? Has to deliberately consider whether this is an advantageous proposition before signing on. And so, in fact, the numbers generated, numbers of contractual stabilization clauses generated under contractual LSCs are pretty good indication, right, that they are the reason, right, that the investors were drawn to invest in this country, in the particular host state involved. And we kind of see a similar data in both Peru and in Peru, as well as in Colombia and Chile. Sorry, just forgot the third country that presented case studies featuring contractual LSCs. All right, so what the data tells us, in other words, then is that we can say with much more confidence that contractual LSCs can in fact attract FDI. The fact that the government can monitor, right, the status of the investments generated under these contractual LLCs allows it to, right, modify it if necessary, or even withdraw it if it finds, right, that it is in fact is not doing what it's meant to do, which is to draw in FDI. And therefore, it gives the government much more control and flexibility in managing the LSC. And contractual LLCs also provide an important and public signaling role in that they present investors with a much more transparent and reliable process to access these contractual stability guarantees, right? Before LSCs came along, right, if we were only counting on contractual stabilization clauses in investment contracts, you know, this would be done on an ad hoc basis, and it would depend on the particular investor having sufficient leverage, right, with the particular host state to negotiate an advantageous contractual stabilization clause, right? With contractual LLCs, any and every investor, right, basically is in a position, right, to have that clause if they choose to do so, given that it would be laid out, right, much more transparently in the contractual LLC. So at the end of the day, the features of the contractual LLCs will benefit not just the investor, but also the host state. Right? And so taking into account then the interests of both investors and host states, right, what we advocate here ultimately, right, is that host states that contemplate LLCs should avoid aspirational LLCs, should reconsider standard LLCs because they can't tell whether it's drawing in FDI, but at the same time may obligate them to stabilize investments, but rather they should adopt contractual LLCs because of all the advantages that I've already spoken to. And I'll end there and take questions. Thank you.
Thank you so much. And thank you everyone for such great presentations. I'm going to first open it up to the audience for questions, and you are free to talk to each other too.
Oh, I have a few questions. If
Go ahead.
Wants to step in. Let's see. For Henry, you seem to suggest, as I understand it, that non-affluent countries, relatively speaking, are presented with more challenges under this new agreement, right? But presumably the 136 countries includes non-affluent developing countries as well. And so I guess the question I have there is, what's in it for them? Why did they agree to this regime? And then for Vera, I have a few more questions just because I do investment law as well. You know, there are two implicit assumptions in your paper, which I think might be advisable to re-examine more closely. The first seems to be that that home states, I mean, what you call non-disputing states. By the way, I would also refer to it as home states just because I think it's less confusing to people who are not in the investment law community. You seem to assume, right, that these joint statements that include non-disputing states or home states are a good thing. And I'm not sure that everyone will agree. Joint interpretive statements are in fact pretty controversial, right? As you know, right, under old NAFTA, now USMCA, right, the FTC could render such joint statements, and they have in fact done so, but they've done so only once. And I think that tells you something. It's because they feared it would be controversial, as it has been, right, in that particular case, when they essentially reinterpreted the FET clause. And the controversy is that when two states to a treaty after the fact issue a joint interpretive statement, what are they doing there? They are potentially revising the treaty, potentially to the detriment, right, of the third-party beneficiaries of that treaty, the investors here. Should they be empowered to do that when the investment treaty, the bilateral investment treaty, in fact invests in the tribunal the ultimate power to determine the meaning of, you know, these particular investment provisions? And the second implicit assumption is that non-disputing states, home states, are presently not able to intervene or to issue a joint statement if they choose to do so with the respondent state. I'm not sure that's true. You know, as you know, right, all fora, including most prominently ICSID, have revised the rules to very liberally allow for amici briefs. In fact, they've now basically left it to the discretion of the tribunal in most cases, right, as to whether amici briefs would be permitted. And I don't know of many cases, certainly not recently, of any cases where a tribunal has not permitted the home state to basically file an amicus brief. So what's happening then if there are no amicus briefs or amici briefs being filed by host states or you know, non-disputing states? I think it's because they don't wish to do so. It's not that they are not permitted to do so. there's very little in for the disputing or the non-disputing states to actually weigh in these kinds of disputes. And in fact, right, to avoid further political entanglement, I think most home states basically keep their hands clean of any disputes between their investors and host states. I mean, not in every case, right? Obviously, where for whatever reason the host state is implicated as well and have interests that they have to protect, then they would do so. But given that it is permissible in many cases to intervene, and that tribunals are very much open to home states doing so, the fact that we don't have them, I think is reflects more the fact that these host states don't wish to be intervening. So I'm going to stop there.
In the interest of time, I just want to make sure that Athena, who has her hand up, also gets to ask her question. So we'll try to get these questions out and then everyone can sort of talk and answer.
Thank you. To the first topic of Professor Einbinder. First question to him was a very interesting presentation. Thank you for your notes, firstly. My first question is, should tax avoidance be treated as tax evasion at the international level? I think of the Pandora Papers. We see so many articles in the newspapers nowadays. The topic comes again and again. Many write on the Pandora Papers, nothing was happened, it's only tax avoidance, international tax avoidance. Should be that treated as a corruption tactic internationally and be punished at the international or the national level? This is first question. The second is the practices of corruption in arbitration. You named a company, not exactly, you referred to a company acting in Brazilian and then in Peru. Could that be Odebrecht? Yeah, Odebrecht was really a great story of more than 30 years. It said that it led a politician to suicide because the corruption practices were open, and the company said, yes, we did it, made an open acknowledgement that many times that happened. And last case, I will cite the article in the chat Fenster. It led in 2019 in a mass arrest of 12 or 14 arbitrators. So that's really a big scandal. And the problem is here apparent. My question is, what, according to your opinion, should be done to change this very bad situation of corruption in arbitral institutions and ad hoc arbitrations? What should be done now to secure the neutrality and non-corruption attitude of the arbitrators? Next topic. Thank you. I have now a question for what we had after that. Yes, Ms. Corsen, thank you for the very interesting topic. I see the topic related to the conflicting opinions in international investment law. One opinion approach says we want more coherence, and this addition of materials in the way of amicus curiae, interpretation of states, previous arbitral awards will help the future arbitral panels to decide the same way. The other opinion says, no, it's not favorable. Arbitration is ad hoc. It serves special needs of the states, and we do not want precedents, because this would lead to a precedent system as we have it in many national jurisdictions. So this is a dimension, a new argument. Are we favorable to this precedence coherence introduction through more through more past arbitral awards, statements of the states, and all that. Amicus curiae letters, I think, is a good thing. Is a great innovation, was added in the revision of UNCITRAL, I think, was UNCITRAL, and the UNCITRAL rules. It leads to some new perceptions of the whole society, of non-governmental organizations. They have something to do because the cases in arbitration affect not only the non-state party, the non-involved state party, the respondent state, and the investor, affect many other societal groups. And that's why I think it's a good thing. Third question and last, in tax, I think I cannot say anything. I mean, it's not my expertise. I can't say anything. Last question is in the topic on legislative stabilization clause. Here we have again classes, different opinions. I'm not pro-investor. I mean, it's a political thing because we have here the politological arguments. If we accept these stabilization clauses too much, we come to a situation in which the states in the future cannot more change the political parties. And no matter how many democratic elections a party has, the people, we the people, cannot elect a party with another legislative program, a new environmental policy that could affect the stabilization clause. That's the main problem, that the state cannot regulate anymore. When we have too many legislative stabilization clauses, then, or contract stabilization clauses, we cannot talk about democracy. As much as more and more we undermine democratic systems. All the elections, the new legislatory programs, the social policies, the wage protection policies, the labor policies, the environmental policies, all that may affect and gravely the investments. And that means it's not allowed under the stabilization clause. Or we come to the conclusion all these legislative policies will be only for the insiders, the national investors, but they will not be loss for the foreign investors. And that it is not possible because all foreign investors have introduced the investment by establishing a company in the investment in the investment state. So it's not possible. We come to undermining democracy. That's my main argument. That's why I do not like it. I am a pro-Calvo doctrine jurist. At the day that the European Court took the decision in Achmea that all bilateral investment agreements between European Union states are not more binding, I made a party. And sorry, that's my political opinion because all that undermines democracy. I respect, of course, all views. The other view says, no, state needs investment, needs finances, needs development. There are other needs. We have to think about all dimensions. Of course, we have to do so. But I think an investor should have taken into account that he needs or she needs the market, she needs more capital, she needs a new geographical area for investment, and undertake the risk to invest under the pledge to respect the legislation, no matter what legislation. He cannot say, I don't like new parties in the future and new elections because I made an investment. It goes far too far away. That's my opinion and 2 cents. Thank you very much for your attention.
No, thank you very much.
Well, I can't resist. Ms. Tafila, so you don't think your first question had to do with tax?
Tax evasion and tax avoidance. Should we regard tax avoidance?
I know, I was joking.
Pandora Papers, we have the problematic as tax evasion.
I was joking because of your statement about not knowing anything about tax.
Yeah. Okay, something.
Anyone have responses or just thoughts in general?
Well, if I might, because you directed it a bit to me, even though I didn't talk about tax.
Exactly.
And I'm sure Henry, if you allow me to call you by your first name, could explain to us the very technical differences. For me, it's a matter of money and getting away with it. Everybody wants to avoid tax, even though people who say that they're happy paying them. And of course, tax evasion is illegal. Tax avoidance isn't. It's kind of crazy. What's the connection to the court? I don't have an answer. Well, actually, I do. Tax havens. We regard tax havens as something that has existed since the beginning of time and can't possibly be played with. I simply don't understand that. Last time I looked at Cayman Islands, I don't think their military force is sufficient that would be able to pull off a concerted attempt with one Marine and to conquer it. So I really don't understand, except the fact that it's needed by people, and it shouldn't be. It shouldn't. I'll tell you stories on the inside. I mean, how did I begin to understand that there was a lot of corruption going on at Alstom, like people at Olderbrecht? It was tax havens. All of a sudden, and you just become an expert. Every major power has their tax haven. The Chinese, it's BVIs. The Russians, it's Cyprus. It's fascinating. So there is a connection. The way, and there's a connection with arbitration, because I don't have a magic wand for the arbitration solution, but it is interesting, your questions, because both tax and arbitration are very connected as areas where you see corruption. It's a signal. So you look at where the money's going and you ask, well, why is this money going through Cyprus? Well, it's Russian. Well, if it's Russian, of course it's going to go through Cyprus. That should ring some bells. So I think pressure needs to be placed more strongly on tax havens. They simply have no power to stop, not to stop tomorrow. The reason they continue is because we allow them to continue, and we have reasons. And then in the old days, or not that old days, oh, it's okay, it's tax, we're just channeling our money there, but there's nothing wrong. There was a study.
Break in, sorry for a little bit, because I just got a message saying there's a hard transition time in 2 minutes.
Well,
sorry,
so
and Vera wanted to, I think, respond to some things. So
yeah, sorry.
No, don't be sorry. We just,
maybe somebody else wants to jump in. I didn't realize. Yeah. It's just arbitration's a wonderful way to corrupt. I'm not talking about the arbitrator. What you have to watch out for are fake arbitrations that are used in a way to disguise corruption. You just set up an arbitration, and then you have arbitrators, and then there's an order, and actually the people have maneuvered not to corrupt the arbitrators completely, but as a way of ensuring they can make payments. I don't know how you stop the arbitrators from being corrupt. I don't have a solution for that.
I'm going to let Vera just really quickly pop in, and then.
I just want to thank for all the questions, and I don't have perfect answers to all of them yet, but I think I keep wondering, to the extent that the Vienna Convention on the Law of the Treaties allows state parties who are signing investment agreements to contribute to their interpretation, it seems odd that in the regular investment arbitrations, we don't get to see, the home state view. And so I don't know how to, separate here treaty amendments from proper joint statements with regard to treaty interpretation. This is, Jared, something to think about. And then with regard to your second question, of course, this is why I'm talking about incentives. And so it's not only that we need to create the procedural mechanisms for home states to interpret or provide interpretations of treaty provisions, but I think some incentives are needed so that we get to see their view. But I really like your comment to the extent that perhaps they actually don't want to be involved, not to go back to state disputes and not to crash the current system of investor-state dispute resolution. And with that, I will need to figure out what the incentives might be to overcome this hesitance. So I guess I have to stop, but thank you.
Thank you, everyone. And thank you for the insightful presentations and questions. And I hope that this makes for a more fruitful scholarly discussion in the future. So thank you very much. Take care, everyone.
Bye-bye.